country and ensures that it promotes and sustains competition in the market. It protects the interests of consumers and it ensures freedom of trade on all market participants. So that's the broad framework under the preamble, pursuant to which the Competition Commission was set up in 2002. It became a working body in 2009 when the act itself was brought into motion, 20th May 2009. And finally, we had certain provisions of the law called merger control provisions that came into force in 2011. So our jurisprudence is about 12 years old, and that's when most of us started out around 2008-9 when we started doing competition law, which then was an unknown territory, at least in India, and most of us had no prior India level or India law training, so to say. The dimensions of the law. So the dimensions of the law are multifaceted. I will, before that, also just give you a broad administrative framework. So the competition law in India is administered by a body called the Competition Commission of India. It is headquartered in New Delhi, and there are plans of opening offices in Bombay and Chennai. The Competition Commission of India is the body of first instance, and all appeals from the CCI, the Competition Commission of India, go to a body called the NCLAT, the National Company Law Appellate Tribunal. All appeals from the NCLAT go to the Supreme Court of India, which is of course the final authority on any competition law dispute in India. There is also a very important arm of the CCI called the DG's office, the Director General's office. The DG's office helps in investigation of companies, helps in preparing reports on whether certain companies may have contravened the provisions of the law or not. So the DG's office is an arm of the CCI, but is tasked with independently assessing whether a transaction or a behavior of a company or a group of companies has contravened the provisions of law. So that's the purpose of the DG office. It's headed by a senior IRS officer. The CCI itself is a body of 3 or 4 members headed by a chairperson who of course typically is also a IAS or a retired bureaucrat. The NCLAT, like most of us who are advocates over here know, is also in New Delhi. And then you have the final authority, the Supreme Court of India. So that's the broad structure of the CCI. The dimensions of the law are 4 or 5-fold. The first and the most important dimension of law is anti-comparative agreements. I will delve deeper into it, but broadly, anti-comparative agreements are bad under law, and the assessment itself is done by the CCI to make sure that such agreements are not entered into, and if they are entered into, companies are reprimanded for the same and penalized by the regulator in India. There are penalty provisions under law, which we will discuss as we go forward. So that's the first dimension of law, where anti-competitive agreements are held to be illegal under law, and we will discuss in greater detail subsequently what are the types of agreements which are not okay. The second dimension of law is abuse of dominance, where large corporations and multinational companies are penalized by the Competition Commission and appealed if by the CCI in the NCLAT and the Supreme Court, penalized by those 2 courts also, if a company is found to have contravened the provisions of Section 4 of the Act. Section 4 is the relevant provision pursuant to which companies are debarred or are forbidden from abusing their dominant position. We will, as we go ahead, discuss a little about abusive dominance as well. But right now, I'll just limit myself to discussing what the broad heads are. So like I said, the first broad head is anti-comparative agreements. The second broad head is abuse of dominance. The third broad head, which now I'm going to discuss, is merger control. I'm sure most of you have seen that last 3, 4, 5 years, there have been lots of large mergers and acquisitions in the market. Bayer, Monsanto, IHH, Fortis, ArcelorMittal, SR Steel, Power Finance Corporation, REC. These are all large transactions that parties have undertaken either voluntarily or because of directions from, let's say, the Prime Minister's office, if it's a disinvestment transactions, all large transactions have to be notified to the CCI, which is you need an approval of the CCI before you close such transactions. All large transactions have also to be vetted and approved by the Competition Commission. So that's the third leg of the CCI's broad framework. The fourth dimension of law is advocacy, where there is a statutory mandate under the Competition Act for the Commission to do competition advocacy, tell the world, including PSUs and government corporations, about the existence of law, about the powers of the Commission, about how a company or a corporation may use the powers of the Commission itself if they have themselves faced competition concerns by, let's say, a group of retailers, distributors, raw material suppliers, or by anybody else. So that's the third dimension, or the fourth dimension of law, where parties have the power to go to the CCI and ensure that they train PSUs, they train government corporations, they train the other stakeholders like private companies as well on the importance of competition law, on the powers of the Commission, on the powers of what a Don raid is, on the powers of the DG himself. And then there is another power called inter se advocacy, where commissions and various regulators themselves can exchange information, discuss potential concerns, refer matters, refer policy issues. The Commission in India, which is the CCI, has powers to discuss issues which may have overlap with the SEBI issue, with the SEBI, which may have a banking law issue with the RBI, with the state excise regulator, if that regulator is the nodal agency. So that's broadly the framework under which the Competition Commission of India operates into. And I'm just going to reiterate for the few of us who've joined right now. So we are discussing the broad dimensions of the law, and I'm just going to restate what I did. The first dimension of law is anti-competitive agreements, where the Commission looks at all agreements which may be bad under law because they may be in the nature of a cartel or a territory allocation agreement, or in the nature of a bid rigging tender. So that's the first dimension of law, where the Commission has the powers to assess anti-competitive agreements. The second dimension of law is abusive dominance, where the CCI has the powers to penalize companies for abusing their dominant position in the market. We will discuss this as we go ahead. The third dimension of law, like I said at the start, is a merger control, where all large transactions that breach certain financial thresholds are mandatorily notified to the Commission, and only once approval is received from the Commission is when a transaction can close. The fourth dimension of law is competition advocacy, where the Commission is mandated under law to train people to spread awareness about the existence of the law and the powers of the Commission. And then there is another ancillary dimension, which is advising state governments, central government, advising other regulators, advising other state corporations on how they should deal with certain issues that come to them and how they should report it to the CCI if required. So broadly, these are the dimensions of the law. I'll quickly also go back to the structure of the competition regime in India for a few of us who've just joined. The structure of the CCI is three-pronged. The first level of a scrutiny or of investigation is at the Competition Commission of India. That's the body of first instance, where all competition disputes are resolved and companies penalized. All appeals from the CCI go to a body called the NCLAT, headquartered again in New Delhi. All appeals from the NCLAT go to a body which all of us know about, called the Supreme Court of India. So these are broadly the three legs of the structure of the competition regime in India, or the regulators in India. There is, of course, another ancillary body to the CCI called the DG's office, the Director General's office. The DG's office is empowered with the role of investigation of matters, where they can raid companies, they can investigate officers and directors, and they can pass their report, basis which the CCI then makes a decision as to whether there is contravention or not, and whether a company or a officer director should be penalized or not. So that's broadly the structure of the CCI in India and the competition regime in India. Now, the first broad head that I had discussed, and I'll spend about 5 minutes now on the same head in greater detail, is anti-competitive agreements. Anti-competitive agreements are broadly of two types: horizontal agreements and vertical agreements. And as the name suggests, a horizontal agreement is an agreement between people, between companies at the same level. So agreement between a bottle manufacturer with another bottle manufacturer is in the nature of a horizontal agreement. And then there are 5 types of such agreements that are penalized and prohibited under law. The first such agreement is a price fixing agreement, where companies directly or indirectly agree to, for example, fix the purchase price or the sale price of products. So if 2 airlines agree that the base fare that they charge on a ticket from New Delhi to Bombay shall be mandatorily 3,400 rupees, that is in the nature of a price fixing agreement and is prohibited under law. Now, what is important to note over here is that all horizontal agreements are per se bad. What do we mean by per se bad? They are bad as soon as you enter into such an agreement and a competition regulator or an informant who goes and files a complaint, he is only mandated to establish the existence of that agreement. As soon as the CCI gets to know of the existence of the agreement, they have the powers to penalize parties. What is also very important and interesting to note over here is that it is on the charged party, the opposite party, to then prove that either they weren't in such an agreement, or if they in fact were in such an agreement, they will have to establish that the agreement did not cause AAEC in the market. What is AAEC? Appreciable adverse effect on competition in India. Now, if one is unable to establish as a company that the agreement did not cause AAEC in the market, the CCI will penalize such officers, directors, and the delinquent company itself. So a horizontal agreement is per se bad. As soon as you get into that agreement, whether written or oral, whether over an email or WhatsApp, whether over a telephonic conversation or on the back of an envelope, any agreement that you enter into with a competitor, which is in the nature of, number 1, a price fixing agreement; number 2, an agreement to limit or control production; number 3, an agreement to share market data or market resources or the territory itself; or any agreement which is in the nature of bid rigging or collusive bidding in a tender, either by a government organization or a PSU or third parties. All such agreements, I'd reiterate, I'm going to say this again, are in the nature of a horizontal agreement, which are bad under law. The relevant provisions are Section 3(3) of the Act, where a price fixing agreement is per se bad. The second that I discussed is a limitation of control of production or supply or investment. For example, 3 tire manufacturers, A, B, and C, they agree that, right now there is less demand in the market due to COVID-19, and the sales of cars are very less. If all of us reduce production by 30%, our prices will be stabilized. So an agreement between these 3 tire manufacturers, A, B, and C, to agree to reduce production by 30% is a cartel, is a violation under law, and is per se bad. Similarly, if 3 companies enter into an agreement where they say, hey, I am a large player in North India, Mr. B, you are a large player in Southern India, and Mr. C, you are a large player in Western India. Let's allocate territories. Why don't you service customers in northern part of India? I will service customers in Southern India, and company C will service customers in Western India. This agreement is in the nature of allocation of market, allocation of territory agreement, and again is per se bad. It is bad as soon as it is entered into, and the CCI has powers to penalize. There are about 200 or 300 odd cases where the CCI has mounted such investigations, has penalized parties, and has penalized most importantly, the officers, directors in charge of such violations. So the crux of a Section 3(3) violation, a cartel or a horizontal agreement violation, is that it is per se bad, and it is then an obligation on the charged party to prove that the agreement either wasn't in existence, or that even though the agreement was in existence, it led to efficiencies in the market and was entered into to help and uh, cooperate with consumers, and that it led to consumer welfare and not company welfare. So horizontal agreements are per se bad. They are bad as soon as you enter into them, and it doesn't matter whether the agreement is in the nature of a written, signed, stamped, executed agreement, or a back of the envelope discussion recorded by two players. So these are horizontal agreements. The second type of agreements which are not okay under law are called vertical agreements. As the name suggests, vertical agreements are entered into by people in the vertical supply chain. For example, an agreement between a supplier and a distributor, an agreement between a raw material provider and a manufacturer. All such agreements happen all the time, but if they are in the nature of a tie-in arrangement, if they are in the nature of an exclusive supply arrangement, if they are in the nature of an exclusive distributorship agreement, or if they are in the nature of a refusal to deal or a resale price maintenance, then they will be also not okay under law and can be penalized by the CCI. The test of a vertical arrangement to check if it breaches the competition regulations and the laws in place is different. Like all of us understand, not all exclusive supply and exclusive distribution agreements are bad. Many times they're essential for facilitating efficient movement of goods, facilitating efficient supply of services, and therefore the test that one applies when assessing a vertical arrangement is called a rule of reason test, a ROR test, as we call in the competition law parlance here. A ROR test is an assessment where the informant, the complainant, has to satisfy to the commission's understanding that the agreement between a raw material supplier and a distributor, or a raw material supplier and a manufacturer, led to appreciable adverse effect on competition in India, failing which a case cannot be sustained at the CCI. So I'll just repeat myself. One has to establish that a vertical arrangement between two players in the market has led to or will lead to appreciable adverse effect on competition in India, failing which investigation will not be mounted on such party. So there is a clear distinction between horizontal agreements and vertical agreements. A horizontal agreement is per se bad. It is bad as soon as you enter into it, unless if you satisfy to the commission that it had pro-competitive justifications. A vertical agreement, on the other hand, is fairly okay under law, unless if the complainant is able to satisfy to the commission's understanding and belief that the agreement causes or is likely to cause appreciable adverse effect on competition in India. So the tests are fairly different. The assessment is fairly different, but yes, if you enter into a tie-in arrangement, exclusive supply arrangement, exclusive distributorship agreement, a refusal to deal, or resale price maintenance, then these agreements are bad under law if AAEC is established. Now, what is a tie-in arrangement? I'll quickly spend a few minutes on each example. A tie-in arrangement is in the nature of a bundling of two different sets of products. For example, you tell a consumer or a raw material supplier or a distributor that I will sell you tires only if you also purchase wipers from me. So if two independently sellable units, which is a tire and a wiper, or a tire and a steering, are clubbed together, and they are forced upon a consumer, a dealer, or a distributor as a mandate that you necessarily have to procure both from me if you want tires from me, then that is in the nature of a tie-in arrangement. And if one is able to substantiate that, this arrangement is only for price gouging or for ensuring that the downstream entity is forced to buy both, then such arrangement is a violation under law and will be penalized. Similarly, all of us have seen supply arrangements in place. A supply arrangement in the nature of an exclusive arrangement is also very common. For example, a Pepsi or a Coke having a exclusive dealer or distributor in New Delhi or NCR, that's fairly common. But one will have to satisfy that the exclusive arrangement is pro-competitive, has benefits accruing to customers in the nature of better pricing, better services, better after-sales services, better offtake, better sales planning. So if one is able to satisfy that consumers are benefited, then a supply arrangement, even if exclusive, is okay. If a supply arrangement is not for the benefit of the consumer, but is only to, help the entity entering into such arrangements, then it's not okay. So again, like I said, vertical arrangements are not bad under law. They're not per se bad, but they may be bad if one is able to establish AAEC in the market. The fourth such arrangement, which is again bad under law, if proven, is a refusal to deal. So if I am, let's say, a Hyundai dealer, and I sell my cars through distributors in Northern India, in NCR, and then I choose not to deal with one dealer, not because he doesn't have the criteria to sell my products, not because he doesn't have the wherewithal to sell my products, not because he doesn't meet the essential government requirements to become a dealer distributor, but for some arbitrary reason. If I choose to discriminate between two dealers or two distributors or two customers for some arbitrary reason, for something which is not justifiable under law, then that is in the nature of a refusal to deal. So if Maruti Suzuki, the largest player in India in the automobile sector, decides not to deal with me because they don't like the color of my shirt or they don't like the color of my skin, then that is in the nature of a refusal to deal. Of course, a Maruti Suzuki can choose not to do business with me if, for example, I don't have the technical capabilities, if I don't have the economic capabilities, if I do not have the relevant licenses in place, if I do not have trained personnel, if I don't have NOCs from government bodies to set up shop. So for legitimate reasons, refusal is okay, but for illegitimate reason, for no valid reason, if there is refusal, then that is in the nature of a refusal to deal and can again be penalized under law. The last such broad vertical arrangement, which is not okay under law, is a resale price maintenance agreement. All of us understand what resale price is. So if, for example, I am a manufacturer of cars, I am, let's say, Toyota Motor Corporation. I give my car to the largest dealer in India, let's say ABC Corporation. And that transaction, of course, is in the nature of a sale purchase transaction. So I have entered into a sale purchase transaction with the dealer distributor. And he has purchased 500 cars from me to sell to the end consumer like myself in New Delhi or somebody else who has joined from Bombay or Pune. If any of you have once made that purchase from the dealer distributor, and if the dealer distributor is mandated by the car company that he will not sell below a particular price. For example, the dealer buys a Toyota Fortuner from the manufacturer at 17 lakhs 50,000. And then Toyota tells the dealer distributor that you shall not sell this car at below 18 lakh 75,000. That mandate by the manufacturer is an illegal mandate and cannot happen. Competition law wants to ensure that there's efficiency at every horizontal level. So they also want competition and efficiency in the distribution market for cars. And therefore, they don't want car manufacturers to impose such obligations on a dealer distributor that they are mandated not to sell below a particular price, even if it makes commercial sense for them. So for example, if after purchasing a Fortuner at 17 lakh 50, if the dealer wants to sell it at 18 lakh 25, he has and should have the discretion, and a company cannot mandate it to ensure price stability in the market. So these are broadly the 4-5 types of vertical arrangements which are not okay under law. I will discuss one case because we have about an hour to do this and I'm already halfway through. There was a famous case at the CCI which went up to the appellate bodies also, called Express Industry Council of India versus SpiceJet, Indigo and Jet Airways. These three airlines were allegedly in collusion for a component of fare called base fare. A component of fare called fuel surcharge. So if you look at a ticket that one buys, especially for the cargo segment of business, the ticket has various heads: base fare, queue charges, ADC, airport development charge, taxes, cesses, and then there is also a component of fare called fuel surcharge. Now, all the companies said that fuel surcharge is to ensure that there is some discretion for airlines to correct rates whenever there's fluctuation in the cost of fuel, which is ATF, and whenever there's fluctuation in the dollar value, basis which payments are made not just for ATF, but for leases of aircrafts, for payment of salaries to expat pilots, for payment of a lot of other foreign resources that they take on. So the CCI got information from a group of travel agents that these airlines are cartelizing. They said that these airlines have fixed a component of price called fuel surcharge. The CCI looked at evidence. They saw that there were 28 or 29 instances when prices had increased for FSC, fuel surcharge. Out of those 28 or 29 increases, there were about 5 or 6 instances when the prices had gone up at the same time and to the same quantum. So all the 3 or 4 airlines had increased the prices by 2 rupees or by 5 rupees in the same time frame. And the CCI was of the view that there was no rational justification for them to increase the prices at the same time to the same tune, especially when there was no paperwork to suggest that the prices ought to increase because of increase in costs or increased in any other component of costing. The parties were penalized 150 odd crores. It went in appeal to then a body called the Competition Appellate Tribunal, which now has merged into the NCLAT. They were sent back, the orders were sent back to the CCI on certain PNJ principles. And the CCI reinvestigated and passed another penalty order on the parties. And the parties have now gone ahead and challenged it at the NCLAT on again certain procedural and penalty issues. So that's one case I'll discuss for now. It's called Express Industry Council of India. It tells us what is cartelization, fixing of prices or a component of price. It tells us that there needn't necessarily be an agreement in place. A cartel can also be entered into by tacit conduct, by conduct which has no evidence on paper. And it also tells us that the penalty obligations on parties are huge. So 151 crore penalty obligation on 3 airlines is a huge obligation. Of course, it got stayed for certain reasons, but penalty obligations of the CCI are also fairly large. So if we remember, I'll just go back. I had said that there are 4 or 5 divisions of or dimensions of law. The first is anti-competitive agreements. And I've very broadly, this is a very nuanced law and one needs to study this for many years to understand the workings of the law, to understand the jurisprudence behind it, to understand the policy behind it. But very broadly, an introductory section, in this introductory session, I have been able to cover what anti-competitive agreements are. They are either horizontal anti-competitive agreements or vertical anti-competitive agreements. As one goes ahead and proceeds, one will notice if one practices in this area of law or goes ahead and studies this further, each topic itself is so nuanced that one can spend many months understanding a subpart of what I just discussed in the last half an hour. A typical master's program on these issues takes a couple of years, and one still feels that one hasn't read and known enough. I've been practicing in this area of law for more than 10 odd years, and I still feel that I'm learning every day. So these are very nuanced economic based laws. One needs to delve deep to understand these, but I think this is a good introductory session to understand what the first principles are, and it will give us a good insight into what one needs to do if one wants to work in this area, practice in this area, study in this area, or teach in this area of law. So the second component is abuse of dominance. Abuse of dominance is essentially a situation where a dominant company abuses or shortchanges a customer or a downstream entity because of the market power that it enjoys. Abusive dominance case is sustainable if one is able to establish a couple of things, or maybe actually three things. The first step in an abusive dominance inquiry is to establish what the relevant market itself is. In what market does the company operate in? And one has to then assess if one is dominant in that relevant market. After assessing whether a company is dominant in that relevant market, one has to assess if one has abused that market dominance. And if one has abused, there are penalty provisions in law, and a penalty of up to 10% of the turnover of the parties, or in the case of cartels, 3 times the profits of the company for the period of cartelization can be imposed. In the last 10 odd years, roughly speaking, the CCI has imposed penalty of about 14,000 odd crores on multiple companies. They have also imposed penalties on multiple officers and directors in charge. They have imposed penalties on other stakeholders like trade associations themselves and on their office bearers. So the penalty obligations are very severe. A company can be penalized up to 10% of their turnover. And for large companies who have turnovers in billions of dollars, a 10% penalty obligation is a very, very huge and a very detrimental obligation, sometimes leading to loss of market power and loss of presence in the market itself. So a 10% penalty obligation is a huge obligation, and therefore companies are extremely wary of competition violations. One will never see a company, at least in the current times, wanting to voluntarily violate competition laws. So I'll just repeat. The second leg that one looks at is abuse of dominance issue. Abuse of dominance issue is where one establishes first that a company is dominant in the relevant market. Then one establishes that the company has abused its market power. There are parameters and guidelines given in the law, which are fairly detailed. I'll cover a couple of them given the time that we have. So abuse of dominance case established once you establish the relevant market. What is the relevant market? A relevant market is the market in which a product is substitutable from another product. So in the market, for example, for supply of cement, the CCI has said that gray cement is different from white cement. In the market for services of airlines, the CCI has said that travel by air is different from travel by rail because the cost of operations are different, the time frames are different, the costing of tickets is different, and the consumer preference is different. Therefore, the relevant market is travel by airlines. And then there is a relevant product market, which is this. And then there is a relevant geographic market. In which geography are you dominant? So in that, the CCI looks at interchangeability and scope of the geography itself. The CCI will say that, you know, an OND pair if it's the airline sector. For example, you're dominant in air freight or air travel between New Delhi and Bombay, because if I as a consumer wants to travel between New Delhi and Bombay, my only options are all flights originating in New Delhi and landing directly at Bombay, and therefore the relevant market over here will be the provision of air services for passengers between New Delhi and Bombay. Once the relevant market has been defined, the CCI will then assess whether you are dominant in that relevant market. Now, dominance itself is a very, very complicated concept. There are multiple factors that one has to assess. There are multiple jurisprudence that one has to go through. There are multiple other item points that one has to assess. Very broadly speaking, you look at about 8 or 9 types of parameters, market shares being one of them. So typically, and very broadly speaking, if you have a market share of about 35 to 40%, you will be construed to be dominant in that relevant market. And once dominance has been satisfied, if after that one can establish that the dominant entity has either directly or indirectly imposed unfair or discriminatory terms and conditions, or has imposed unfair and discriminatory pricing in the sale of purchase of goods, or has limited or restricted the market, or has indulged in practice which leads to denial of market access, or has forced certain additional contracts or obligations on parties because of the dominance that they enjoy, then those impositions, those unfair terms and conditions are sufficient to establish abuse of dominance. The details are there in section 4 of the Competition Act, but very broadly speaking, if one is able to establish that a company which has large market power or has high market shares or has very significant influence over consumers or has a product offering which is critical, like consumer drugs or like life-saving cancer drugs, if one is able to establish market power, market presence, high market shares, dependency of consumer, low countervailing buying power, if one is able to establish these things, one will be able to mount a abuse of dominance case on the delinquent party, and the CCI has powers to investigate and stop such conduct. The CCI also has powers to impose penalty. I think the most important or the most read about case of abuse of dominance in India is the DLF case. Like all of us know, DLF is a large real estate company in northern India. They were penalized 630 odd crores by the CCI for abuse of dominance. And I'm just going to tell you whatever is publicly available because of certain reasons. The CCI felt that DLF was abusing its market power in the sale of high-end residential units in Gurgaon. So that's the relevant market. The CCI said that the terms and conditions in the apartment buyer agreement were unfair. For example, the ABA, the apartment buyer agreement, said that if there's delay on the part of DLF to give you a unit, they will pay you 5 rupees per square feet as delayed penalty. But if there's a delay on the part of the consumer who purchases a flat, the penalty obligations will be very high of 18% interest on the delayed amount. Similarly, DLF had the discretion to increase the heights of the building, and therefore, this case that I'm talking about, DLF voluntarily and on their own without approvals from the parties who'd already purchased, increased the height of the building from 19 floors to 29 floors. The ABA apparently also said that if there's escalation in the price of steel, wood, coal, cement, labor, even if there is delay on DLF's part, the hike in these things will be borne by the consumer, even though they have agreed to a price point when they signed the ABA. So there were such terms and conditions which were highly unilateral. They were imposed on buyers who have no countervailing buying power. And the CCI said that this is highly abusive and penalized parties. One can say that, some of those points were not correct. Some of the findings of the CCI have been challenged at the NCLAT, at the Competition Commission appellate body, which was in existence then, called the Competition Appellate Tribunal, which now has merged into the NCLAT. The case finally went up to the Supreme Court and is pending adjudication right now. Of course, the parties have been mandated to deposit the full penalty amount with the registrar at the Supreme Court, but the case itself is pending adjudication right now. So that's probably the most landmark case and the most popular case, I must say, of abuse of dominance. And it's a very popular company. Most of us have at least heard the name. A lot of us have properties in those condos in Gurgaon. So I think DLF is a fair case for one to very broadly understand what an abuse of dominance case can and is. The third broad case and the third broad dimension of law is merger control. What is merger control? Every large transaction that one sees in the market, whether it is ArcelorMittal buying out Essar Steel, IHH buying out Fortis Healthcare, Power Finance Corporation buying out Rural Electrification Corporation. There are tons of cases. There are about 900 cases that have been notified to the CCI in the last 7-8 odd years. Each case that is notified, merger control case that is notified to the CCI, is assessed to check if there is concentration of power which cannot be controlled, to check if it leads to any appreciable adverse effect on competition that cannot be allowed, to check if the parties have any efficiencies that emanate from the transaction or not, to check if any illegal conduct is being entered into. Once all these checks and reviews are done by the CCI has powers to approve the transaction. The closing of a transaction can only happen after approval has come through. There are certain thresholds prescribed under law which need to be tested and assessed, and only if those tests are breached is one required to make a transaction filed, is when one is required to file a transaction to the CCI. The first level of thresholds are called de minimis assessment, de minimis thresholds. These are provided by the Government of India, Ministry of Corporate Affairs, which says that small transactions don't have to be notified. Now, what is a small transaction? If the target entity, which is the selling entity in India, has asset base of less than 350 crores or a turnover of less than 1,000 crores in India, then the transaction is exempt and should not be notified to the CCI. So this is the de minimis test. The second test that one has to do is a substantive test, where the assets and the turnover of the combining parties, which is the acquirer and the target, are assessed. If they breach certain financial thresholds in the nature of asset and turnover thresholds prescribed in law, then they are again notifiable at the CCI and one has to seek a prior approval. There are certain other exemptions given under law, which is, for example, for banking sector transactions, certain banking sector transactions are exempt. So there are lots of exemptions given from time to time by the Government of India to exempt certain class of transactions because of the policy considerations involved. So if a policy requires that a particular set of transactions shouldn't be notified, then exemption is given. Otherwise, all large transactions that meet the de minimis test and that breach the financial thresholds prescribed in Section 5 of the law are required to be notified to the CCI. Competition lawyers are, prepared and are able to handle these transactions. They are very significant, sometimes as high as $66 billion. That's probably one of the highest transactions that we've done as a firm, which was Bayer AG's acquisition of Monsanto company. $66 billion global transaction, and it was approved in about a year and a half by the CCI because of the significant concerns that the CCI thought there were. We were able to sail through and get a timely approval, and the transaction is probably the most deliberated and the most investigated merger matter at the CCI. So that's the third limb of the competition regulator, where parties have to notify the CCI of large transactions that they enter into, and they need to wait for approval from the commission prior to closing such transaction. I will quickly spend about 5 minutes now on what is the role of the competition regulator, and I will spend maybe a couple of minutes on the current COVID situation and what is the role of the competition regulator in the current times. I think we are in very critical times, and therefore one needs to understand and assess that as well. So on the first part, I think the role of the competition regulator is very straightforward. One is mandated as a competition regulator in India or in the US or the EC to ensure that there's fair competition in the market. Second is to ensure that there is consumer welfare in the market. Third is to ensure that any anti-competitive conduct or abusive conduct is immediately not only stopped but reprimanded in terms of penalty obligations. And fourth is to train all of us, to educate all of us in the market, especially in newer markets like India, China, Pakistan, Bangladesh, Sri Lanka, where the competition regimes are 10, 15, 20 odd years old, to train us on the importance of this very critical area of law, and to train us why it is essential not just for consumers, but also for other market participants like companies, for PSUs, for government corporations, and to tell us how we can use it to our own benefit. For example, you might be a company yourself, but you might be purchasing raw material from a raw material supplier. Let's say a steel player purchasing raw material from another raw material supplier. You need to know your own rights and duties, and you need to tell the upstream, the guy, if certain conduct is in violation of law. So therefore, the role of the competition regulator is fairly important. Globally, there are competition regulators in about 120 countries. The larger ones are the US FTC in the US, the Department of Justice, which criminally sanctions such conduct. That's called the DOJ, the US DOJ. And then you have the European Commission, which is in the European nations. You have the CADE, the CADE in Brazil. You have the ACCC in Australia. You have the Competition and Markets Authority, the CMA in UK. You have the Pakistan's Competition Commission. You of course have the Competition Commission in India. So each country has a very robust and a very strong regulator. India is also catching up. India is also doing fairly well. There is a very strong set of jurisprudence that has developed at the CCI in the last 10 or 12 years of operation. They are very rigorously investigating companies and officers. They have penalized, I would say, more than 500 companies by now. They have imposed penalties of over 15,000 crores. So the penalty obligations, like I said at the start, are huge. And one wouldn't want to be in a violation of law because of the reputational risk involved, the loss of share price if you're listed, the loss of job if one is an officer director, and the other various implications in India and abroad if there is a cross-border issue. So a lot of regulators like the JFTC in Japan, the US FTC and the DOJ in UK, in the US have criminal sanctions. So they can, send parties and company officers to a jail and prison term if they have violated the provisions of the law. And therefore one needs to be wary of this, and one needs to use it to one's advantage also if one can. So that's the broad role of the competition regulator. Next 3-4 minutes I'll spend on the role of a competition regulator during COVID itself. Again, it's a fairly nuanced topic. I did a session for over 2 hours on this broad head called COVID and the role of the competition regulator. I will spend broadly 2-3 minutes just to tell you very briefly of what the role is. It is probably a bird's eye view. It's probably a view from 30,000 feet above the issue, but it will give us a good insight and a good understanding of why a competition regulator is very important. In fact, the role of the competition regulator is more heightened in these times. So, like all of us may have seen, there are lots of issues in terms of lockdowns. A lot of companies have ceased operations. A lot of companies are facing concerns with respect to transportation issues, with respect to supply of goods, even though they are essential products. For example, it's a company making masks. For example, it's a company making PPEs. It's a company making drugs for the pharmaceutical sector. It's a company making sanitizers. It's a company making hospital beds, or it is a company making ancillaries to these. For example, it is a company making injection bottles for the pharma sector. A lot of these companies are facing very significant supply chain concerns, where the raw material is not reaching them, where, for example, labor is not reaching them, where, for example, a component of their own product, for example, if you are a syringe manufacturer and the plastic that you buy from a third party, he is unable to supply that to you, then your own operations are stopped, even though you are a critical component of the supply chain for COVID-19. So competition regulators across the globe have come out with very detailed guidelines. They have in fact gone ahead to say that, certain collaboration between competitors is going to be okay if it's for COVID purposes. So like I said at the start, a collaboration with a competitor to price fix, to discuss costs, to discuss pricing, to discuss allocation of territory, to discuss stabilization of price, to discuss customer allocation. All such agreements or discussions with competitors are per se bad. But in these COVID times, many competition regulators, including the CCI in India, has come forward with very detailed guidelines on what conduct may be okay, even if it is in the nature of a collaboration or under quotes, a cartel between companies to supply, let's say, PPE to doctors, or to supply plastic to syringe manufacturers, or to supply sanitizer to hospitals in India. If you are able to satisfy to the commission that it is for consumer welfare, it is for efficiencies that are otherwise not available to the parties, if one is able to satisfy to the commission, then even these agreements currently are going to be okay in the short term till the COVID situation is ongoing. So therefore, the role of the competition regulator is very, very critical right now. Most regulators are coming forward with very strict and very clear guidelines on what conduct is okay and what may still not be okay. And India is no far behind. India is also very strongly advocating the role of these companies, whether they are food manufacturers, retail manufacturers selling groceries or selling eggs or selling chicken in the country, or they are other essential suppliers like kerosene, petrol, lubricants, plastics, anything which is essential for making these critical components and goods and services. So such conduct, if it's efficiency enhancing and if it leads to consumer welfare, is going to be okay and will not be prohibited or penalized under law if one is able to satisfy the commission on why they entered into this conduct. So I think I will stop on this point. I'm going to open this up for another 5 to 7 minutes for any questions. You can type your question in the Zoom group chat panel on the right hand side. If there are no questions, I'm going to stop in the next couple of minutes, and I'm going to thank all of you. Nitesh, thank you for hosting this, and thank you each participant who raised these, who got in and set this up. It was a pleasure speaking. I'm happy respond to any questions right now, or you can write in. I'm just going to type out my email address here because I've done a fair amount of these sessions and I get a lot of follow-on questions. So you can write in on this email address and I'll be happy to respond to your questions.
Rudresh, I think there is one question from Sangrito. If you can look into that in the chat box.
So that's a brilliant question. I agree. Number one, the competition regime in India was fairly nascent. The jurisprudence in India was fairly less. And one needed a dedicated regulator at the appellate level also to review and assess competition issues. They are very nuanced issues that a regular court probably does not have the wherewithal to address. And therefore, one should have not disbanded the compact. The compact was functioning fairly well. From what we heard, the then finance minister of the country, who was also the minister for MCA, felt that there was consolidation which was required for regulators, and therefore a lot of regulators were merged. In the last 2.5 years of the NCLAT's operation, we've seen that competition matters have not progressed very much. And therefore one has seen that pendency of competition matters at the NCLAT is fairly high. And therefore the government of India very recently has decided that they will set up a dedicated competition bench at the NCLAT. And therefore, I think post COVID-19, we will have a bench or probably 2 benches at the NCLAT that will only deal with competition matters so that they progress more speedily. And there is a set of eyes who only looks at very nuanced and very sophisticated questions of law and fact with respect to competition law that most regular judges may not be able to review and assess. And therefore, I agree. You've raised a good point and I agree with your point.
Rudresh, one more thing. What is with regard to the resale pricing competition as of in the present times of COVID-19? Resale pricing competition, which you talked about, Rudresh.
So resale price maintenance is an issue under law. One cannot prescribe a minimum selling price once the sale transaction has happened. It doesn't matter whether it is during COVID-19 or pre or post that. A resale price maintenance is a problem under law. One cannot determine the sale price of a third party once the sale transaction between the first and the second party has gone through. So that's not okay under law.
Okay, thank you. So,
there's another question. Feasibility of awarding compensation under 53N doesn't function really well. Time consuming. Can it still be considered a nascent stage? Well, so, compensation is a fairly nuanced topic. I think you are probably in an area where you practice competition law, or at least know the nuances of the law. Compensation claims are brought in at the NCLAT directly once the CCI has found a violation and it has been confirmed by the appellate authorities. Typically in cartel cases where the aggrieved party can satisfy the NCLAT that they were overcharged because of cartelization between, let's say, tire manufacturers or steel manufacturers. And then the NCLAT can award compensation to the buyers who purchased steel or tire from those companies. yes, it is a very nuanced topic, and the NCLT is very wary of looking at these issues. There have been a few pending matters at the NCLT for compensation. We are ourselves part of one of the largest compensation matters at the CCI, at the NCLT, where we are representing a food corporation called FCI with respect to cartel of certain products by three large companies called UPL, Excel Crop, and one more company that whose name I don't recall right now. So yes, very recently new set of judges has started looking at compensation matters and competition matters at the NCLT, and we are hoping that they will, speed in the process and do better going forward. Yes, I would still say we are in a nascent regime because we are only about 10 odd years old. Competition regimes in the US are over 200 years old. In the EC, they are over 30, 40 years old. And in most other developed countries, they are over 30, 40 years old. So compared to the US, the EC, the FTC, the JFTC, the KFTC, we are fairly new. And things in India don't move as fast. And therefore, I'd say that the competition regime in India is still fairly nascent. Oh, okay. The third question. You are saying that the merger control thresholds under law are fairly vague, given that they're asset or turnover based. Tech giants might misuse the thresholds. So that's already a very good question. Your questions are very intelligent. I'm happy to respond to those. 2 points. Number one, the asset and the turnover based thresholds are borrowed from various other jurisdictions like the FTC and the DOJ in the US. The CCI realized that certain tech sector transactions like Facebook, WhatsApp did not have to go through the CCI's rigor of investigation because they were fairly small in terms of their asset and turnover base, even though otherwise they're giant corporations, whether it's Facebook or WhatsApp when they were independent. And therefore the CCI suggested to the Ministry of Corporate Affairs in a committee that was set up called the CLRC, the Competition Law Review Committee, where they said that there should also be a transaction value threshold. So in addition to the asset and the turnover threshold, there should be a transaction value threshold, which means that if there is a large transaction size, for example, $1 billion transaction, even if the asset value, let's say, is 100 crores and a turnover of 500 crores, it should still be notifiable to the CCI because of the large scale of operations of the players globally and the large presence that they may have in a digital space, which may not have large assets or turnover attributable to them, and therefore such transactions should be notified. The recommendations of the MCA have been put in the report called the CLRC. They are reflected probably in a bill pending in Parliament. Once the bill is passed, one may get to see a transaction threshold also in picture. But right now, you are right. There is a lacuna in law where large tech transactions sometimes don't have to be notified to the CCI because of the small asset or turnover base that they have in India.
Thank you, Rudresh, for the wonderful lecture which you have thrown on the Competition Commission and the competition law. And at the same time, the view which you have given, I don't think it was a bird view. In my opinion, it's an eagle view which you have given to the topic. And the precious time which you have thrown from your the official works. I'm also thankful to Mr. Anand Garg, another partner, Rudra and Luthra, to make you available for us for this technical topic for all of us which are waiting. Thank you so much, Rudresh. We are obliged to you for this wonderful lecture. Thank you.
Thank you so much. Take care. Bye-bye.